on plea of guilty with your attorney?
Yes, sir.
Plea form tells me you're 34 years of age. Any issues at all reading, understanding the English language?
No, sir.
Now, the charge you're pleading guilty to, assault in the 4th degree domestic violence, that is a gross misdemeanor. The maximum penalty on conviction is 364 days in jail upon conviction and or a $5,000 fine. You realize that?
Yes, sir.
You realize I'd be free to impose up to the maximum regardless of what's recommended by the city and by your attorney?
Yes, sir.
Appropriate. Is that correct?
Correct.
If I accept the plea, you give up the rights contained in paragraph 5 in the form, no trial, no appeal, simply a sentencing. Are you giving up your rights to go to trial?
Yes, sir.
With that in mind, as to one count of assault in the 4th degree domestic violence alleged to have occurred within the city of Yelm on April 19th, 2023, how do you plead, guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes, sir.
Anybody make any threats or promises to make you plead guilty?
No, sir.
I will find the plea to be freely, knowingly, and voluntarily made. Now, I understand this is in the nature of what they call an Alford plea. Is that correct?
Yes, sir.
An Alford plea, briefly, means that you're not admitting to any wrongdoing, but you have gone over the discovery in the matter, the police reports, and are willing to concede that were the matter to go to a trier of fact, a judge or a jury, there's a likelihood of being convicted of the crime for which you're pleading guilty. Is that correct?
Correct. Yes, sir.
The recommended sentence in the plea form is all jail time suspended on the condition of just simply no criminal law violations. I'll ask the city, is there anything in addition to that? Any domestic violence evaluation, treatment?
Just what's in the guilty plea, Your Honor.
Mr. Abergilly?
We can't really hear the city speak. It's really low volume on this end.
He's indicated that they're not recommending anything in addition to what's in the plea form. Mr. Abergilly, anything further from you?
Well, you know, I know, you know, one could look at his history and say, hey, more needs to be done here. I think he recognizes that this relationship with this person has been kind of a toxic relationship, is I guess maybe how I would describe it. He realizes he needs to just remove himself from that situation and not have, you know, contact with this person. You know, I don't know how practical it would be based on Your Honor's question. I don't know how practical it would be to impose, you know, conditions in this court. I would suggest that these are issues in the long run he probably needs to deal with. He can also deal with them by just staying out of trouble, and which he insists that he will, and to stay away from this person, which he insists he will. He's interested in, you know, not being present in Yelm and kind of moving on with his life and getting on with his life somewhere else if he can. So I would just suggest, you know, I think it's sufficient to impose time served. He's not really in a position to pay costs. I don't believe the city was recommending any court costs. And just with the admonition that, you know, for the next year or more, but at least for the next year, that he just remain law abiding and abide by any orders the court issues with regard to contact or otherwise with the other individual concerned in the case. So he'd just like to move on from this and get this behind him and move on to better things, Judge.
Mr. Ward, you have what they call a right of elocution, which means you can tell me anything you think I should know before I impose sentence. You don't have to say anything, but if you have anything to say, now's the time for that.
No, sir. No, sir.
Miriam Whitman is in the courtroom. Ma'am, would you like to say anything with regard to the matter? Mr. Ward, your record does not speak well. You have quite a history of violating no contact orders, among other things. I'm not going to go into the details of it, but your history concerns me. The effect that, you know, it goes back quite a ways, and you don't seem to have learned anything from it. We spoke on the telephone when you were arrested. I'm required to do that, determine whether or not there was probable cause for the arrested detention, which I did find. But I was a little concerned at that time that you didn't seem to quite grasp the difficulty you were in, or the nature of any problem that you might have. It's that concerns me rather greatly. So one of my responsibilities here is to do what I can to ensure public safety. I am going to enter a formal no contact order with you prohibiting any contact or coming in within 1,000 feet of Miriam Whitman. Mr. Haverco, that will be in O courts when I signed it, and I want you to go over with Mr. Ward the difficulty he's in should he happen to violate that order.
I think he understands, based on my discussion with him, I think he has an understanding of the significance of a formal no contact order and the importance of abiding by the conditions.
Conditions of the sentence would be no criminal law violations. I'm also going to order that within the next 90 days, Mr. Ward get a domestic violation evaluation, and then comply with any treatment recommended. Yes, sir.
If I may, sir, I did 2 years of domestic violence classes. I've just completed them recently, or they were never actually fully completed. I am a transient in the area, or was a transient, and my house was burnt down there in the city of Yelm, to where I was not able to complete those classes. But to spend another $3,500, what the total is with the class that they're most likely going to give me, I cannot afford that, sir. I can bring you certificates for multiple classes that I've completed, and and I understand where you're coming from. But
when was it completed now?
That one was actually never completed after upon.
Or the dates.
I believe around 2020 is when I was in the classes. I did them both with.
Where did you see it? In custody or out of custody?
I was out of custody.
Okay.
I was out of custody.
You remember the agency?
I don't recall at the moment.
How
But
long were you in the class?
I was a year.
Okay. He doesn't recall the treatment provider, but in or around 2020, he was in a class that lasted for approximately about a year. You think you could recall where the classes were?
If I was able to go there and get the information, yes. But from this point, sitting here, no.
If he's, I think what he's saying is that if he's released, he could probably travel. He knows where it is. He just can't remember the name. If he was able to travel there, he could probably get some documentation about what he did there. And if Your Honor might be satisfied by that, he could provide that to the court.
That I'm not interested in. What I was trying to get at was, did the treatment precede the incident for which he's in custody at this time? It did. In other words, it didn't seem to do a darn bit of a good. I have reviewed the reports in the matter, and I do find that there is more than a sufficient legal basis for the plea. Ms. Woodman, based on anything that's transpired, is there anything you'd like to say at this point? I am going to enter a formal no contact order that you'll be given a copy. Mr. Ward, I'm going to do something I think I've done less than a handful of times. I'm not going to go by the recommendation of the city. I'm tempted to sentence you to 364 days in jail. I'm not going to. I'm going to sentence you to 364 days in jail and suspend 304 days of that. I'm sentencing you to 60 days in jail. I'm going to give you credit for 9 days served, since that's how long you've been in there. Now, I'm going to set a review hearing in this matter for.
If you may, with your honor, I would like to withdraw my plea then and take this to trial. If I'm going to do the same amount of time, I would like to withdraw my plea then.
Could you back up from the microphone a little bit?
I apologize. I apologize.
Would you repeat what you said?
If that is the case in this matter, I'd like to withdraw my plea and continue on to trial.
But Your Honor, if I could just have a brief moment here with my client here.
Yes. I wish you wanted me to type. Now I'm getting the reload. So I hit the refresh button and punched out reload. Because that was.
So Glenn. Yeah, all that should, it should update as I'm doing it for you, so that's weird. That it didn't. Ish. Yeah.
And they have to start in school. It shows you still editing. There's go, hey.
Okay, so that would.
That should tell the jail.
Yeah.
What they need. Not gonna
Has
post
to give us
anything.
further. Yeah.
Well, Your Honor, Mr. Ward, I think he wants to withdraw his plea. He doesn't want me as his attorney. Said something about filing a bar complaint. Not sure where to go from here. I'll still represent him, but he has to be willing to at least cooperate with me, but, at the same time, it could be sort of a conflict if,
I believe there is a
if
conflict of
he's gonna
interest
file a
here.
bar complaint. I'm just trying to give him some advice on his case, but,
That, I'm gonna, at this point, deny any motion to, withdraw the plea. I will entertain a motion to withdraw the plea. That must be in writing and filed with the court. The sentence, excuse me, that I previously imposed does stand. Mr. Pendley, excuse me, Mr. Ward, a copy of the judgment and sentence will be given to you. And the formal no contact order likewise will be given to you. It is very important that you read that carefully and abide by that fully.
Yes, sir.
We're going to set a review hearing for July. What I'll expect you to do is appear at that review hearing, and I'll expect to have you be able to file some proof as to an evaluation and treatment at that time. All I can do is the best that I can do. That's
I apologize one more time, Your Honor. I will put my best effort into getting an evaluation, but they are $350 that I do not have. I'm on a fixed income and I'm currently homeless. Like I understand it, and I will put my best effort into doing that for you.
in the judgment and sentence, there is information and a requirement that you contact our probation monitor. Do so. I know there's financial help available to get evaluations and treatment. That is available. I know I'm not up on that, but that's where you start. Good luck.
Yes, sir.
And again, I should remind you, your firearm rights have been suspended pending reinstitution by a court. Good luck.
Yes, sir.
Appreciate it, sir. Aaron, have safe. Is Your Honor ready for the next matter?
If you just give me just a
You bet. Sorry, Judge.
Mr. Haverko, go ahead. Apologize for the delay. I needed.
Oh, no, I know, Your Honor had a little more than average paperwork on the last matter. This is Aaron Crossman. These are item numbers 3 and 4 on the 8:30 in custody calendar. They come on before the court for an arraignment. He is indigent and would like counsel appointed.
Mr. Crossman, I'm going to appoint Mr. Haverko to our public defender there to represent you in this matter. Has he had a chance to discuss the matter with you at all?
Yes, sir.
Mr. Haverko?
Thank you, Judge. So I have had an opportunity to discuss both of these matters with Mr. Crossman, and we were able to discuss the factual basis in each of the cases by way of the police reports. And we talked about what an arraignment is, being brought before the court, being read the charges in open court, the elements of the offenses that would need to be proved, the maximums that can be imposed, the right to trial, and so on. And too often, enter not guilty plea. Not that notwithstanding, he would prefer to waive a formal arraignment with a full understanding of his rights and enter pleas as indicated in the plea form, which I prepared and I have reviewed with him, and would ask Your Honor to inquire.
Go ahead, sir. Do you disagree with anything at all that Mr. Haverko just said?
No, Your Honor, I don't.
For the record, is your name Aaron Richard Crossman?
Yes, sir.
Mr. Crossman, let me first say this before we proceed. I don't like to keep people in jail. The use of jail is to me should be significantly limited, but you've got this one case going back to 2016 and another case in 2021, and we just haven't been able to get you into court. But I want to say that I'm glad that you're before me now, and we can deal with your matter. I'll defer to your attorney here. Mr. Haverko, do you have anything to add?
Nothing to add, Your Honor.
For the record, your full name is Aaron Richard Crossman, sir.
Yes, sir.
Crossman, I'm looking at a statement of defendant on plea of guilty to one count of theft in the 3rd degree. That's ticket ending in 1288, date of violation June 21st, 2021. The plea form also notes a dismissal of the theft charge filed in February of 2016. Now, the charge you're pleading guilty to is a gross misdemeanor. The maximum penalty on conviction to be 364 days in jail and or a $5,000 fine. If I accept the plea, I'd be free to impose up to that maximum, regardless of what's recommended. You realize that?
Yes, sir.
Now, if I accept the plea, you also give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. I want you to make sure you understand that, okay?
Yes, sir.
With that in mind, as to one count of theft in the 3rd degree alleged to have occurred within the city of Yelm on June 21, 2021, how do you plead guilty or not guilty?
Guilty.
Make that plea of your own free will.
Yes, sir.
Anybody make any threats or promises to you to make a plea guilty?
No, sir.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement of paragraph 11 does satisfy the factual elements of the plea. City, have anything to add? Mr. Haverko, anything to add?
Oh, nothing to add, Your Honor. He realizes he's, in jail because he just missed, court dates, and he apologizes for that. It's a no jail time or just suspended jail time recommendation, and I would ask the court to follow it.
I'm going to follow the recommendation 364 suspended on the condition of law-abiding behavior. Mr. Crossman, not going to impose any fine in this matter. And I want to urge you to, hey, if you get a citation, you got to take care of it. They don't go away, warrants get issued, and eventually the chickens, they come home to roost. So this takes care of this matter. You won't hear from us again unless there's a violation of the condition of suspension, and that condition, of course, is no law violations. Mr. Crossman, good luck to you. You take care of yourself. Okay, you'll get a copy of today's paperwork, review it, and if you have any questions about it, give Mr. Haverko a call, okay?
Yeah, thank you. We'll get up to it. Okay, great, thanks.
We're on record and doing the in custody, so we do have a brief gap here. If somebody has something, anybody has anything that they can present quickly,
We have a SSD,
I think we can handle that. Yes. Good morning, sir. Is this Zachary Lee Montello?
Yes, sir.
Mr. Montello, I'll defer to your attorney for the status of the matter set for pretrial this date.
Yes, Your Honor, and good morning. For the record, Tony Gartswell on behalf of my client, Mr. Montello. Your Honor, we have reached a resolution with the city. In this case, we would be entering into a 12-month SOC. The paperwork should be complete outside of a date that would set the final date on. But it's a 12-month SOC, which at the end, as long as Mr. Montello complies with everything, would be amended down to a negligent driving. Close that out at that time. I have gone through that document line by line with my client, answered any questions that he may have. He understands it's a contract, and as long as he lives up to his end of the bargain, he'd get the benefit of that bargain. Gone over the important constitutional rights that he's giving up by entering into this. I believe he'd be entering into this knowingly, voluntarily, and intelligently. Your Honor, if I may approach, I'm also handing forward the completeness of the freedom with the NSP and he's done that you guys.
A perfect date. Thank you. Montello, a lot of this is boilerplate, but I would like to review significant parts. Montello, do you disagree with anything at all your attorney just said?
No, sir.
He has negotiated an agreement. It's a contract, basically, under the terms of which, if you comply with the terms, the charges will be reduced 12 months hence to a much lesser charge of negligent driving in the first degree. I've said on many occasions that a conviction for DUI is worse in terms of impact on your life, your record, etc., than quite a few felony convictions. You owe your attorney a debt of gratitude for negotiating an agreement that really greatly reduces the impact. As your attorney said, it's important that you comply with the conditions, because if you violate them and the city proves that by a preponderance of the evidence, we're back to a trial based on the police reports, and you know how that would probably work out. I'm going to wish you the best of luck. I'll sign off on the stipulated order of continuance, and I'm going to wish you the best of luck. It's often said, and I agree, I found that true to be for myself in my own life. If we don't learn from our mistakes, we're condemned to repeat them. I'm going to wish you the best of luck. You take care of yourself. I'm signing off electronically as we speak. And of course, you'll have a copy of the continuance order. Review it again, and if you have any questions, stay in touch with your attorney.
Yes, sir.
The stop is agency that I'm very familiar with. They do good work. But hey, I hope that was at least a learning experience to go through that process.
Absolutely.
Good luck to you.
Thank you.
Take care.
Thank you very much.
Thank you, Your Honor. Good to
Thank
see
you.
And the, at the final hearing, since the president waived if he's in compliance or,
Presence waived if there's a full compliance. Stay in touch with your attorney. Make sure if you change your address or contact information, you let us know, just in case. I don't anticipate a problem, but just in case there is.
Okay.
Good luck to you, sir.
Thank you very much.
thank you, Your Honor.
Thank you.
Thank you. Counsel.
And a signed copy that can be gotten at the clerk's window on the way in.
Thank you.
Mr. Habaco, if you can hear me, we're ready for your matter.
Thank you, Your Honor. So this is Megan Bilka. She's got two matters on today. She's number one and number two. They actually come on for pretrials because she was previously appointed to Joshua Sneva. So first things first, she would ask that I be appointed on these matters in Mr. Sneva's stead, and then we have our proposed resolution.
You are appointed.
Oh, thank you, Judge. So anyway, I've gone over these cases with her, and I've reviewed the police reports, and we've come up with a proposed disposition. I prepared a plea form, which I've reviewed with her, and would ask Your Honor to inquire.
Good morning, ma'am. Is your full name Megan Christine Belka?
Yes, sir.
Let me first say this. We spoke on the phone. Well, we have it on more than one occasion. I don't like to keep people in jail, but I thought that this was probably the only way to keep you from going into warrant status time after time. Over the statement of defendant on plea of guilty with your attorney.
Yes, I have.
Plea form tells me that you are 34 years of age. Any problems reading, understanding the English language?
No.
The plea would be to 2 counts of theft in the third degree on April 4th and then on April 15th of 2021. Have you gone over the plea form with in the process with your attorney?
Yes.
And you realize that I'm able to sentence you to up to 364 days in jail and up to a $5,000 fine on each charge, regardless of what's recommended. You realize that?
Yes, Your Honor.
And if I accept the pleas, you go up to 5, no trial, no appeal, simply a sentencing, and that would conclude the matter.
Yes, sir. Yes, Your Honor.
With that in mind, as to 2 counts of theft in the third degree, alleged to have occurred within the city of Yelm on April 4th, and then again on April 15th of 2021. How do you plead, guilty or not guilty?
Guilty.
Do you make those pleas of your own free will?
Yes, Your Honor.
Anybody make any threats or promises to you to make a plea guilty?
No.
I will find the plea to be freely, knowingly and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements. I've heard the recommendation. I've read that in the file. Mr. Ratchell, anything to add? Mr. Habaco, anything to add?
Nothing, Your Honor. And again, she understands that she's in custody because of failure to appear issues, but she's happy to be here to take care of these matters. And the city's otherwise recommending just, credit for time served, balance everything suspended to be released today, and ask the court to follow that.
Ms. Belka, anything you'd like to tell me? You don't have to say anything, but now's the time if you have anything you'd like me to know.
I just hope to get this cleared up so that I can no longer have to deal with this and hopefully stay out of trouble and as I have since this has occurred.
I'm going to go along with the recommendation, 364, all suspended on the condition you have law-abiding behavior. Just stay out of trouble. That's the only thing we require of you. I'm going to wish you the best of luck. And again, if you do happen to find it necessary to go to court, please do so. Avoid having to sit in a jail. and deal with me over the internet. I'm gonna
Yep.
wish you the best of luck, Ms. Belka. Unless there's some other hold on you, you'll be released today. Good luck.
Thank you, Your Honor.
You're good,
Thank you.
yeah, you'll be out in an hour or whatever.
Probably before dinner.
Well, before that, I think you're out in an hour or two or so.
We'd be off when there's scores if you can get a ride. For that.
And with that, we'll go off record. Call the matter of number 2 on the 9 o'clock docket, Yelm versus Marcel Harris. I understand counsel is present on by way of Zoom. Go ahead and on.
Now I'm on. Good morning, Your Honor. Nathan Trudeau standing for attorney of record with Dan Garrell on Marcel Harris Jr. this morning. He's appearing through counsel pursuant to 3.4, which I believe was previously authorized, unless that's him there in the courtroom.
Yes, sir. Mr. I'll ask him for the record. Marcel Dwayne Harrison is present and at the council table. Mr. Harris, your attorney, Mr. Trudeau is appearing by way of Zoom this morning. But Mr. Trudeau, I'll defer to you for the status of the matter.
Your Honor, this morning defense is requesting to set this matter out. We're looking to continue it about 30 days for purposes of negotiation.
No objection.
Hearing no objection from the city, that's exactly what we'll do. I'll need something in O courts.
Absolutely, Your Honor. Let me go ahead and fire that up and I'll get it filed promptly.
Mr. Ratfield, could you?
I can put it together.
Mr. Trudeau, Mr. Ratfield's right here in the courtroom. He'll prepare the document.
Oh, thank you, counsel.
Mr. Harris, everything is on a computer screen these days with what I'll do is electronically sign an order, resetting the matter out a month and that's the way things go with criminal charges. They require a lot of negotiation, discussion, and discovery before they can proceed. Any conditions of release earlier set remain in effect, and that would include, of course, remain in touch with your attorney. Any questions, Mr. Harris?
No.
May 25th. Mr. Trudeau, does May 25th work?
May 25th looks like it does work for
9 o'clock.
Mr. Garrell. Yep, that'll be just fine, Your Honor. Thank you.
Mr. Trudeau, do you have the document in front of you?
I'm pulling it up right now, and it looks like I see the motion continue. I'm gonna go ahead and sign that.
Any necessity to address the speedy trial issues?
I would like that waived.
This would be with a waiver, Your Honor.
The new commencement date, date of next appearance, May 25th.
That would be just fine.
Now sign the order resetting the matter. Mr. Harris, you can get a copy of today's order by going to the window again. Keep in touch with your attorney and we'll see you back here in about a month. Any questions at all?
No.
Take care. That concludes the matter.
Thank you, Your Honor. I did have one other matter. It's actually on the 10 o'clock calendar. I'm standing for the attorney of record, Gina Buskirk, on the Jason Turner matter.
Who's your client on the 10 o'clock?
I believe it's Jason Turner, Your Honor. That's cause number 3A0188277, 278, and 279.
Got it. That's page 5, docket numbers 8, 9, and 10.
And Your Honor, my understanding is that Mr. Turner is in fact appearing through counsel under 3.4 this morning. This is also a defense motion to continue for investigation with a waiver of speedy trial. And I am just checking in O courts now to see if a waiver has been uploaded by his attorney.
Yes, it is. Looks like that's being reset to May 25th at 11 o'clock in the morning. Your client is not present.
And I'm authorized to waive and certainly provide notification to Mr. Turner as well.
Any objection from the city? No objection. Presence waived. Resetting Mr. Turner's case to May 25th. We'll be sending him a copy of today's order. Mr. Trudeau, that takes care of that.
Thank you, Your Honor. I believe that is all I have today.
I believe so. But thank you for appearing. You take care. Have a good one.
Thank you as well.
I will. Try. Take care.
Thanks. Bye for now.
let's go on record. Well, the matter of Yelm versus Joseph Wachowski. I'm sorry, it took me a moment to kind of catch up to where I realized that there was a private counsel matter.
No
But
worries
the-
at all, Your Honor. And good morning for the record, Attorney Jay Crone here on behalf of Mr. Wachowski, who is present to my right. We are here for disposition today. The parties have reached an agreement and an SOC has been uploaded to O-Courts. I have gone over that paperwork with Mr. Wachowski in detail, including the important constitutional rights begins up by entering the agreement, and also what happens if he's successful at completing its terms, and as well what happens if he is not successful. So I believe he is prepared to into that knowingly, voluntarily, and intentionally. Thank you.
Mr. Wachowski, for the record, your full name is Joseph John Wachowski.
Yes, you're right.
Do you disagree with anything at all? Your attorney just
do not,
indicated
Your
to me that was. I'm looking at in O-Courts, an electronic version of a stipulated order of continuance. It's basically a contract negotiated by your attorney with the city under the terms of which 24 months down the road, this charge will be dismissed if you comply with a number of conditions. To me, the most important one is that you learn from this, that you don't make the same mistake that was you're accused of making back in December. Now, in return for the agreement here, you'll get the dismissal if you abide by the agreement, but if you violate the agreement and the city proves that, we're back to square one. If they prove by a preponderance of the evidence that you violated, we'll look at a police report and you know what that would result in. Your attorney has negotiated you a path out of this matter. I've said on more than one occasion, and I'll say it again now, that in terms of impact on your life, a DUI conviction is worse than any one of a number of felony convictions. You have a way out of this, but whether you do so or not, take advantage of that, that's up to you and not your attorney or anybody else. I'm going to wish you the best of luck. I'll sign off on this. Again, the maximum penalty would be 364 and 5,000 if convicted. Are there any costs involved in this? I don't see any entered. I see a 0 entered in the. There should be.
Yeah, that's.
The monetary obligation is $250, and that'll be added here in a moment. The other obligation you have is to get a drug and alcohol evaluation and file proof within 90 days of the court exceeded that done well within 90 days. So.
We've also discussed the victim impact panel, Your Honor, as well, and we're working on getting invasion treatment as well.
Victim impact panel is also specified in the agreement, but it's also part of the recommendation made by your evaluation. Hey, you've been proactive here. Yeah, the most important thing is that make sure you learn from this and don't repeat it. I'm sure your attorneys advise you the penalties that are mandatory on conviction just escalate rather dramatically over time. More than one person sitting in jail for a year because they did not learn. I'm going to wish you the best of luck, Mr. Wachowski. Hopefully, we do not require a reappearance given the dismissal in this charge in 2 months, but stay in touch with your attorney and make sure you keep a current address on file with us. If you move, change your contact information, make sure your attorney or us knows.
Oh, that's right.
Any questions at all?
I'm all set.
Mr. Wachowski, I wish you the best of luck. You take care of yourself.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. And with that, we'll go off record.
Mr. Duncan?
Non-record, Mr. Everco, I'll defer to you for the order in which the cases are called.
Thank you, Judge.
Is this Stephen Wayne Duncan?
Yeah.
Mr. Duncan,
Yes.
good morning to you.
Well, this matter comes on for a pretrial hearing. We have submitted a motion for continuance. He has, two other, no contact order type cases outstanding, one in Lacey and one in Olympia. The one in Lacey might be coming up for trial soon, so just wanting to defer this until after some of his other court dates.
How far out would you like to go?
I'd say at least 60 days.
June 22nd or July 6th?
How about July 6th?
Let's go July 6th. Mr. Duncan, conditions of release here, of course, law abiding behavior. Your record is impressive to say the least. That's no law violations. If you violate the conditions of release, which are, of course, no law violations, you're going to be back in custody. You don't want to do that. July 6th, 10 o'clock. So Duncan, I want you to sign off on the order of reset.
So you need to sign this back.
So Duncan, I've now signed the order of reset. You can get a copy of that by going to the window outside the courtroom and to your left. Stay in touch with Mr. Haverco, no law violations, and we'll see you back here in July. Any questions?
Just get my contact information from. Yeah. Next matter, Judge, would be Graceland O'Neill. That's number 7 on the 10 o'clock. Ms. O'Neill, which one have a seat?
Good afternoon, ma'am. Is your full name Graceland Jean O'Neill? Matter set for a pre-trial. Defer to your attorney for the status of the matter.
Okay. Oh, well, Your Honor, this matter comes on for a pretrial hearing. Parties have reached an agreement. Just no prior record. We've submitted a stipulated order of continuance, 12 months, $250 court probation fee, dismissal if on compliance.
Ms. O'Neill, I'm looking at the stipulated order of continuance. What that is a contract negotiated between yourself and the city through your attorney, under the terms of which you need to stay out of trouble. Learn from this. We don't learn from our mistakes, we're condemned to repeat them. 250 in costs. That's the least important thing to me. The most important thing is you've learned from this and you do not reoffend. The benefit of the contract, if you fulfill its terms, is you get the charge dismissed. It does not go on your record as a conviction. On the other hand, if you violate the agreement and the city proves that by a preponderance of the evidence, we'll have a hearing based on the police reports, and that could subject you to up to 364 days jail and up to a $5,000 fine. I sincerely hope that you've learned something from this. We need to learn from our mistakes and go on to make new ones and not repeat old ones. Any questions at all? I'm going to wish you the best of luck. What I want you to do is go to the counter, You can get a copy of this, the agreement. I want you to read it over carefully, and if you have any questions at all, give Mr. Haverco a call. And make sure you have a current address on file with either Mr. Haverco or the court, okay? Ms. O'Neill, I wish you the best of luck. You take care of yourself.
Tammy? Yeah, that's a good thing.
Okay. I forgot to ask you about
Yeah.
the insurance part.
Well, that's a separate thing. That's the certificate that we'll be dealing with today. The SOC will be for 12 months. Probation fee of $250. Pay $25. Sign right here.
Mr. Haverco, this is,
Oh, this is Tammy Brooks McReynolds. It's number 1 on the 11 o'clock. And so anyway, we parties have reached an agreement, that being a stipulated order of continuance for 12 months. No criminal law violations for the next 12 months, $250 probation fee at the end of that period of time. If she complies, it'll be amended to a negligent driving in the second degree, a civil infraction.
there's a no insurance site as well as that,
No, we're not
Part
handling
of that
that.
is
That's just
dismissed,
between,
or-
that's, no, well, it's just between the defendant and the city.
ordinarily that's dismissed as part of the plea bargain.
Okay. Okay.
Could I have to, ma'am, for the record, is your name Tammy Brooks McReynolds?
Yes.
I'm looking at this stipulated order of continuance. Basically, what that is a contract. I need to go over it briefly to just make sure you understand what you're doing here. It's that we're continuing the matter for a period of 12 months. Now, if during those 12 months you stay out of trouble, pay costs in the amount of $250, most importantly, stay out of trouble, the charge will be dismissed to a civil infraction, which is negligent driving in the second degree. The criminal charge will be not going on your record as a conviction. However, if you agree, if you violate the agreement, you've given up your rights to go to trial. If you violate the agreement, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction and the possibility of up to 1 day short of a year in jail and a big fine of $5,000. You realize that? So that's important. If you're in a collision of any kind, it's you need to stop and exchange information, or just leaving is not an option. Any questions at all?
No.
Ms. Brooks McReynolds, what I want you to do is go to the window outside the courtroom and to your left, get a copy of the agreement, read it over carefully, and if you have any questions, give Mr. Haverco a call. And by all means, keep your address on file here. I can't say that often enough. Any questions at all?
Will I need to come back in a year?
If you're in compliance, you don't need to come in for a final hearing. If you're not in compliance or the city alleges you violated the agreement, you will have to come in. That's why I say, let us know where you can get mail,
Okay,
just in case.
so,
Hopefully you will not have to be back.
so after a year, I'll get a letter if I don't. have
After a
any-
year, it'll go on your record as a neg-2, as a simple traffic infraction.
So what is it gonna be now?
What now?
What?
What is it right now? It's just a pending case. It isn't anything right now.
Okay,
It's, the matter is just being put on hold
okay,
for a period of a year.
okay.
With, if you violate during the year, it could result in a conviction. If you don't, you comply with the agreement, it'll show up on your record as an infraction.
Okay.
So, clear enough? Does that answer your question, I should say?
Yeah.
Ms. Brooks McReynolds, I wish you the best of luck. You take care of yourself, and again, read the agreement over carefully and stay in touch with Mr. Haverhill.
Okay,
Good luck to you.
thank you.
Let's see, next matter is gonna be Aaron Brown.
Brown, good afternoon. For the record, is your full name Aaron Samuel Brown?
Yes, Your Honor.
Okay. Matter set for pretrial. I'll defer to your attorney.
Thank you, Judge. So, I believe the parties have a proposed resolution of this matter. He intends on entering a guilty plea to the DUI. It's amended to that of no test, which would make it the mandatory minimums. And then as part of the agreement, upon the court's acceptance of that plea, the city would move to dismiss the reckless endangerment charge. And the recommendation would just be the mandatory minimums, 1 day in jail. I believe the fine is $990.50, something like that. And there's a minimum of a 90-day license suspension, notwithstanding eligibility from DOL for a probationary type of license.
Again, for the record, Aaron Samuel Brown, do you disagree at all with anything that Mr. Haverhill just said?
No,
I'm looking at a statement of defendant on plea of guilty to one count of driving while under the influence of intoxicants. Plea form tells me you're 34 years of age. Any issues, any problems reading, understanding the English language?
no, Your Honor.
Have you gone over the plea form with Mr. Haverhill?
Yeah.
And if you had any questions as to what you were doing here, was your question answered?
Yes, Your Honor.
If I accept the plea, you give up the rights contained in paragraph 5 of the plea form, no trial, no appeal, simply a sentencing, which could be up to 364 days in jail and or a $5,000 fine, regardless of what's recommended by your attorney in the city. This being a gross misdemeanor. You understand that?
Yes, Your Honor.
That in mind is one count of driving under the influence of intoxicants alleged to have occurred within the city of Yelm on March 7, 2023. How do you plead, guilty or not guilty?
Guilty, Your Honor.
Make that plea of your own free will.
Yes, Your Honor.
Anybody make any threats or promises to you to make you plead guilty?
No, Your Honor.
Find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 of the plea form does satisfy the factual elements of the offense. There is a recommendation that I impose the standard first time penalties. City, have anything further, Mr. Redfield? Mr. Haverhill, anything to add?
Nothing to add, Your Honor.
Mr. Brown, you're allowed to tell me anything you think I should know about the situation or yourself before I impose sentence. You don't have to say anything, but you do have that right.
No, no.
Okay. I'm going to follow the recommendation. 364 days in jail, all but 1 day suspended. The 1 day is mandatory. Is there a recommendation or about this to?
Did you think you had done 24 hours?
Yeah, I did 24 hours in holding.
I'll give you credit for time served. I'll give you credit for time served on that. $990.50 is the mandatory fine. We'll put you on a time payment program. You are required by law to get a drug and alcohol evaluation and comply with any recommended treatment to get the evaluation within, and file it within the next 90 days. The reckless endangerment charge is dismissed as a part of the plea bargain, and please, all you have to do is read a newspaper or turn on the news in the morning and you can hear about somebody that got killed because of drinking and impaired driving and the inevitable consequences that sometimes occur. We kill thousands every year nationally. And it's all, by and large, done by somebody, there's no winners, done by somebody who doesn't have any significant criminal record and wouldn't ordinarily hurt a fly. And of course, somebody loses their life, and their life is gone, and those around them, the life is permanently disrupted. Dependent children, you read about them, a dependent spouse left with being a single parent, et cetera, et cetera, et cetera. Mr. Brown, if we don't learn from our mistakes, we're condemned to repeat them. Hopefully this has been a painful but learning experience. Now the Department of Licensing will take action against your driving record in accordance with their requirements. That I have really nothing to do with. And I wish you the best of luck with that. You take care of yourself, and hopefully this is something that just will never be repeated. Good luck to you.
Thanks.
It's going to take me a moment
Sit there for a
to
second. I gotta wait till this is open and then you have to sign. Okay.
work my way through the paperwork here, the computer work, I should say.
Yeah, sign on this pad. Where's it doing?
Mr. Brown, that concludes the matter. I've signed via judgment and sentence. Please get a copy of that at the window. You do have an obligation to contact our probation compliance monitor. And that's, we look forward to getting the evaluation. The evaluation, the purpose of that is just to make sure there isn't a problem, and if there is, let's deal with it and make sure that nothing goes wrong. Good luck to you, sir. Take
Thank you,
care
Your
of
Honor.
yourself.
Hey, Josh, why don't you come on up? This is, next matter is gonna be, on the 10 o'clock, number 2. Give me a moment.
Good morning, sir.
Hey, Josh, I just need you to sign here. Thanks, sir. So, okay, so this is Joshua Henderson, comes before the court for a pretrial hearing on a theft charge. I've had an opportunity to discuss the matter with Mr. Henderson. We propose a resolution here. He intends on entering a plea to the charge. He's signed the form. Recommendation is that credit anytime served, balance suspended for 12 months on the condition that he remain law abiding and pay a $250 court probation fee, and then the matter can be closed.
Good afternoon, sir. Is your full name Joshua Maurice Henderson?
Yes, sir.
Do you disagree with anything Mr. Haverco just said?
No, sir.
I'm looking at a statement of defendant on plea of guilty to one count of theft in the 3rd degree. Plea form tells me you're 38 years of age. Any problems at all reading, understanding the English language?
So,
Have you gone over the plea form with your attorney?
yes, sir.
Have you gone over the process with your attorney?
Yes, sir.
And if you had any questions about what it meant to enter a plea of guilty, was your question answered?
No, sir.
Now, if I accept the plea, you give up the rights contained in paragraph 5, there's no trial, no appeal, simply a sentencing, which could be up to 364 days in jail and or a $5,000 fine, this being a gross misdemeanor. You realize that?
Yes, sir.
With that in mind, as to one count of theft in the 3rd degree alleged to have occurred within the city of Yelm on August 17th, 2022, how do you plead guilty or not guilty?
Guilty. Guilty.
You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty, Mr. Henderson?
No, sir.
I will find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements. City, have anything to add? Mr. Haverco, anything to add?
Nothing to add, Judge.
Mr. Henderson, you have a right to tell me anything you wish. Do you think I ought to know? Now's the time. You don't have to say anything, but now's the time if you have anything to say.
No, sir.
I'll follow the recommendation, 364, $250 probation fee. Will set you on a payment program. It's my hope that this has been something of a learning experience. The jail time is suspended on the condition you have law-abiding behavior, and that applies especially to theft charges. I think we do have a bail bond posted that'll be exonerated by virtue of the disposition. The bonding company will be notified. Any questions at all? Mr. Henderson, I'm going to wish you the best of luck. You take care of yourself, and whether you have to sit there again is up to one person, really, and that's yourself.
I just went and got a job.
Good.
What, Mr.
So I just went and got a job at the hotel.
Oh, he was just mentioning, Judge, he just obtained a job, employment.
Great.
Yeah.
Hey, no, that's great. Is it something you enjoy?
Yeah, maintenance. Maintenance.
Okay, hey, that's if you enjoy it, stay at it, and
Aaron,
hey, the job is it gives a life a structure. It's something to sort of set your clock by. I should probably be retired at my age, but I enjoy the having a reason to get up and go to work in the morning. I enjoy that. But Mr. Henderson, good luck to you. You take care of yourself. There's some paperwork involved in it. Now, what I want you to do is go to the window and get a copy of it. Thank you for appearing. Thank you for your patience, and you take care of yourself. I will. open. We are back on record, and Mr. Aberco, I'll defer to you for the order in which the cases are called.
Thank you, Judge. One sign of these. Hang on. The next matter is Keisha Jones. It's number 6 on the 11 o'clock. And I think the parties
Good
are reached
afternoon.
an agreement.
Hello.
That being a 12-month stipulated order of continuance, conditions of which are no new criminal law violations for 12 months, pay a $250 the court probation fee. If she'd like to make payments, at the end of which time, if she complies, the city would then agree to dismiss the matter.
For the record, is your name Keisha Lachette Jones?
Yes, sir.
Do you disagree at all with anything Mr. Habercoat just said?
No, sir.
What he has done is negotiate on your behalf an agreement with the city under the terms of which this charge can disappear a year down the road if you abide by certain conditions. 250 in costs. The most important one is to me is law-abiding behavior. Stay out of trouble. And of course, no further issues involving anything that might be construed as an assault. Hopefully, this has been not too painful of a learning experience for you and one not to be repeated at all. I'll be happy to simply dismiss the charge a year down the road, finding you in full compliance with it, but bear in mind, in return for the agreement, you've given up your rights contained in paragraph. There's no trial, no appeal. If the city proves a violation, we'll go to the police reports, and a reading of them will result probably in a conviction, which would subject you to significant jail time. We don't want to go there. You have a chance to get this charge dismissed. I want to thank you for appearing. I'm going to wish you the best of luck, and you take care of yourself, and may all wounds be healed.
Yes, thank you.
I thank you. You take care of yourself. What I want you to do is get a copy of today's disposition at the window outside the courtroom to your left. Read it over carefully, and if you have any sort of problem with understanding what's in there, any questions at all, give Mr. Habercool a call.
Okay.
Any questions of me?
No, sir.
Ms. Jones, good luck to you. You take care of yourself and be well.
You too. Thank you.
Thank you.
Good luck. Aaron Crawford. Can you tell me the number again?
360-561-4114.
561. Yeah, I think I tried to get a hold of it. We weren't able to connect, I don't think, or.
I was on my way down there.
Okay.
Complete dead zone.
It's okay.
I thought that
We'll figure it out.
bad.
We'll figure it out. So this is Aaron Crawford. He's number 5 in the 11 o'clock. Matter comes on for a pretrial hearing on a DUI and hit and run unattended charge. He needs to have an evaluation, and we talked about that, and so we're submitting a speedy trial waiver, a motion to continue, and we'd like enough time for him to get an evaluation, and
Sometimes those take time. How far
I'd
would
say
you like to
60
go?
days, around there.
Sure.
Yeah.
Hearing no objection from the city, we could go to July 6th. Would July 6th work?
Sure.
Proper, sometimes it takes time to get these evaluations. I know that full well. Resetting the matter, any conditions released earlier said remain in effect. And that would include staying in touch with Mr. Haverco, of course. And of course, don't go anywhere near anything that might lead you to a second charge. July 6th, 11 o'clock, I'm signing an order to that effect here. Crawford, what I want you to do is get a copy of today's order at the window outside the courtroom to your left, and Good luck to you, and we'll see you back here after the 4th of July.
Thank you.
Take care of yourself.
You too.
I don't really. Is this? So when you're looking at one of these multi-page evaluations, you know, sometimes I look for the magic words, deferred prosecution, like where it just says it. And I'm looking through all the pages and I don't see it, so I'm like, is this one of those, or
It's,
do I normally say the magic word?
or what? Well,
I mean, it's gotta be a 2-year program, right? So. Because if, you know, it's not a full 2-year program, and it's got, it is.
There's actually two, like, there are two things that are going to be good that year. I have an open CPS case and deferment, so.
hold on until your attorney's here.
Yeah. Blank petition, blank order.
Yeah, I think the recommendation is intensive outpatient treatment for that. I would assume that would satisfy the requirements. If the parties are happy with it,
They didn't, I didn't realize there was a petition in Oak Court.
Mr. Ing, come on up and have a seat.
Come on up, Mr. Ing.
Abaco, as everything is on electronics,
Okay.
and some of the forms are still catching up to Oak Court system, they call it. And apparently, they now have, I didn't know that until a moment ago, they now have the deferred prosecution. The deferred prosecution, sometimes that's a
Thank you.
tougher,
Okay.
it's gonna take your attorney
Is
a
it,
little bit of time to bring that up and conform it to the cases before the court. Basically, what it is a way of getting the
Okay.
charge dismissed on conditions. And I've often thought that it sometimes might be easier just to take the medicine for a DUI conviction rather than to subject yourself to the intensive outpatient treatment. That's a tough road to hoe, but I admire somebody who
Okay.
says that, hey, look, I've got a situation that I need to take care of. I gotta make sure this doesn't happen again. I don't want to sit in jail for a year. Yep.
He signed the petition there, and it's
Well, I have been active in treatment for approximately, 3 months, close to 3 months now. For the deferment, so.
Huh.
It was almost immediately after our last continuance. I started treatment pretty close thereafter. And I think I have around 16 or 17 leanways. The CPS case is actually closing Friday too. So.
That's great. Always glad to hear somebody started.
Yeah.
When they don't have to quite yet.
Well, we did a voluntary placement, but I get my daughter back on Friday. Tomorrow. Pretty excited.
Boy, there's a lot of paperwork involved in this.
there's a bunch of stuff about commencement dates and different things, and
When did you start treatment?
I don't know the exact date, but it was February, end of February, I believe.
We could make the effective date March first. That would be,
Sounds good.
give you credit for a little time under your belt. So,
Thank you, Your Honor. Been very busy.
Well, good job.
Thank you.
Getting it done. Good sign here.
I do better when I can't see my signature than when I can see it.
this is now, there's an awful lot of paperwork. A lot of it's just boilerplate, but what I'm gonna want you to do is read it over carefully, and we can always have another hearing. I'm gonna approve the program today. Let's finalize that. We're allowed to do that, but I will want you to read the paperwork over carefully and make sure we're all on the same page here.
Of course.
And again, I want to emphasize that my hat is off to anybody that jumps into one of these programs. That's obligating yourself to quite a little bit. The cost involved in this, and the money is the least important part to me. 500 is the cost of it. And that's spelled out in the. I'm signing the order electronically as we speak.
Good job, man. That's hard to do, to get all that stuff done. Not very many people do.
It's been a lot.
Yeah. Not a
With
lot.
CPS case and cleaning the property.
Yeah.
40-yard containers, and it's CPS compliant, and then also dealing with restraining order and divorce because not everybody's compliant, doing it on my own. It's been a very long 60 days.
Considering this is one of the lengthier files I have, I should weigh it instead of
Well, this
counting the pages, but
this situation was 3 years ago, Your Honor.
it's yeah, there's but hey, here we are.
I was
Here
off
we are.
track, but I'm back where I need to be.
You know, I want to say you look a lot healthier than you looked the first time
Wasn't doing well.
I laid eyes on you. That's always a good thing to see. That's I wanted, and just keep it, it's not how many times you fall down, it's how many times you get back up, having fallen down. Don't give up on yourself, forgive yourself, move on with life, and hopefully you're finding that sobriety is sort of sharpens the edges of things and makes the world a little bit brighter.
And enjoying the dirt world a lot better. So
I'm absolutely sure of. You take care of yourself, again, stop at the counter, get the paperwork, and again, best of luck. You take care of yourself. We probably won't be seeing each other again, assuming all goes well here. But hey, we'll take it as it comes. If you have to come back in for any reason at all, we'll deal with it. Okay? Take care of yourself.
thank you, Your Honor. Thank you.
Mr. Ray, good to see you.
Thank you, Judge. Next matter on the 11 o'clock would be item number 12, Timothy Willoughby. Living in Menace, we have no class, so it's not going to be refusing.
Oh, you can't see this.
Oh, wait a second. No, it's my fault. You won't see it, but
Oh, I won't just
yeah,
sign.
but yes, yeah. Yeah, it's going. Yep.
That's close.
Yep. Thanks, Judge. So this is Timothy Willoughby. Matter comes before the court for pretrial hearing on a DUI charge. He is going to be entering a straight plea guilty to that of the DUI, but amended to no test. It's to be a no test DUI.
I'm looking at a statement of defendant on plea of guilty. For the record, is your full name Timothy Eugene Willoughby? Mr. Willoughby, I'm looking at a plea form here. The plea would be to one count of driving while under the influence of intoxicants. Plea form tells me you're 59 years of age. Any problems at all reading and understanding the plea form process? Have you gone over the plea form line by line with your attorney?
I think so, yes.
And if you have had any questions, were your questions answered? Now, if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal. Simply a sentencing, which could be up to 364 days in jail and or a $5,000 fine, regardless of what's recommended here. You realize that?
Yes, sir.
With that in mind, as to one count of driving while under the influence of intoxicants within the city of Yelm on January 20th, 2023, how do you plead guilty or not guilty?
Guilty, sir.
Do you make that plea of your own free will?
Yes, sir.
Anybody make any threats or promises to you to make you plead guilty?
No, sir.
I will find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements. The recommendation is for the standard first offense within 10 years. Those are mandatory. Those I have nothing to say about. Does the city have anything further to add to the? Mr. Aberco, anything to add?
Nothing to add, Your Honor. Yes, court follow the recommendation.
Mr. Willoughby, you have a right of elocution, they call it. You have a right to tell me anything you wish. You don't have to say anything, but anything you think I should know or you want to tell me, now's the time. Well, you're lucky you're right here, because there's a lot of courts that I've been in them over the years where based on your record, this is the 4th time you were cited with DUI, where you'd be going to jail for 364 days. I've seen it happen. I don't know how many times. You would think, a person would get that, hey, we've got to separate drinking from driving somehow, some way. That's just, but you don't seem to understand it. I am going to follow the recommendation. In large part, I'll suspend all but one day and give you 60 days within which to serve that day at the Nisqually jail. The other days are suspended on the condition you have law-abiding behavior, and that especially comes to any offenses that involve driving. I will condition the suspended time on a drug and alcohol evaluation within the next 90 days and compliance with any recommended treatment. A little education might, you've probably been through before, but a refresher course probably wouldn't hurt anything at all. There is a mandatory $990.50 by way of monetary assessments. Set you on a payment program with that. Are you licensed now, insured now?
I'm insured. I'm not licensed. They took it away.
That was, how long is it going to be before?
They said a year.
Because yes, as a result of this conviction, this will have an impact on your license as well. And that the Department of License, that's something they do. I don't have anything to do with that. But Mr. Willoughby, good luck. The other caution here is, I'm sure, hope you're aware of this, is that you're kind of a poster child for the person that goes out, gets behind the wheel and kills somebody, or kills himself. I've represented many people who've been in that situation. There's no winners, no winners. I once had somebody sat across my desk from me that didn't care how long the jail, the penitentiary sentence was going to be, because the person that got killed was the spouse that was sitting behind or beside the defendant when the collision took place. I'm going to wish you the best of luck. Those are that's the reason why the penalties are as stout as they are in this. But for the distance between your citations, I would be compelled to give you a much harsher sentence. I'm going to wish you the best of luck.
Thank you, sir.
Take a look at the documents, once you get a copy of them, which you'll get at the window, go over them carefully and, give Mr. Aberco a call. If you have any questions. And in any event, keep a current address on file, if you would. Mr. Willoughby, any questions?
Yes, sir. Thank
Good luck to you. Take care.
Hayden?
We,
Go to sign here. So this is Caden Long. It's item number 7 on the 11 o'clock calendar.
Ms. Long, good afternoon. Or,
Yeah.
well, still good morning.
Matter comes on for a pretrial hearing on an assault 4-3 domestic violence. Parties, I believe, have reached an agreement. That being a 12-month stipulated order of continuance, the conditions of which are pay a $250 court fee, remain law abiding as in no new criminal law violations, at the end of which time the city would move to dismiss the charge.
The record, your name is Caden Long.
Correct.
Have you gone over, it's called an SOC, stipulated order of continuance. It's a contract, is what, have you gone over it with, Mr. Haverco?
What did you say?
Have you gone over this agreement with
Yeah,
your
it-
attorney?
yeah.
And if you had any questions about it, were your questions answered?
No, you already
That was-
answered them.
This is a chance to get the matter taken care of, but the most important thing is stay out of trouble, learn from the situation. In return for getting the matter off your record, you're giving up your rights to go to trial. If you violate the agreement and the city proves that, we're back to square one. I'll read a police report and that'll almost certainly result in a conviction for the charge, and we don't want to go there. If you have a chance to have the matter resolved very much in your favor, but you need to take care of that. Now, this is kind of a lengthy, and things are a little bit confused in a courtroom. I want you to get a copy of today's agreement at the window, read it over, and give Mr. Haverco a call if you have any questions, okay?
They'll tell you. She was wanting to know when her first payment would be due. Okay.
As long, the least important thing to me is the money. The most important thing to me is you stay out of trouble. If you have trouble making the fine payments, don't just ignore them. Let us know. Let us know. We can deal with that quite easily. Good luck.
Thank you.
Yeah, see you later. Mr. Langston?
Takes longer to. Done.
Next matter, Judge, is on the 10 o'clock, Scott Langston, last name Langston. I've been awaiting a response from the city. I believe the city may have a motion on this case.
Yes, Your Honor, city moves to dismiss without prejudice.
Like I said, I'm sure you have no objection to the charge being dismissed without prejudice.
No, I just curious about my vehicle though.
Pardon?
My vehicle that was impounded for over this.
That's your,
I mean, it was impounded on the facts. They said I tried to say I aided and abetted somebody, which I didn't do, and now I don't have a vehicle now. Is there a way to get it released? The impound?
that you need to take that up with the police department.
Okay.
Should be. released now with the dismissal.
Okay, thank you.
Mr. Langston, the dismissal is without prejudice. What that means is the city could refile the case, should they see fit to do so. Based on further information, further discovery or reconsideration. I noticed you're probably the most impatient person I've had here in quite a weeks.
My right, he's about to lose his foot, he's got a doctor's appointment, it's not that does. Yeah, I kept hearing 11 o'clock getting called when I was on 10 o'clock again, I was just curious. Maybe he's, cause he said he's in a lot of pain right now.
Unfortunately, you never know how long cases are gonna take. And I wish there was a way of speeding things up, but there really is.
I apologize for that.
But no problem, but it's, it doesn't help your situation at all, the display.
I understand, I'm sorry.
Mr. Lyson, I've signed the order. You can get a copy of that at the window outside the courtroom to your left. Good luck to you. You
Thank
take
you
care
so
of
much.
yourself.
Thank
You have a good day.
You gotta go there.
I will. Well, it's a bright sunny day.
Yeah.
And sometimes I just make friends wherever I go.
Right, exactly.
We're off record. Except. We're now on record for the 1 o'clock arraignment calendar. Before I call you up one at the time, I need to advise you of a couple of things. This is your first appearance in response to the issuance of a criminal citation. Today's an arraignment. You need to know that you have a right to have a lawyer represent you at all stages of any criminal proceeding, including today. Mr. Haverco will be in the courtroom in a moment. He will, in any event, enter a plea on your behalf at this time. The plea at the arraignment is invariably not guilty. That's not any great statement about the case. What that does is preserve your rights pending a pretrial hearing. Pretrial hearing, that is what gives you the chance to discuss your case with your attorney and have your attorney negotiate or perhaps discuss the case with the city's representative, Mr. Ratfield, who's seated here to my right, your left. If the case is resolved, the resolution can be put on the record. If it's not possible to resolve a case by agreement, you have a right to a public and speedy jury trial in the county where the offense was alleged to have been committed. I'll call you up one at a time. If you have any question at all regarding your rights or what you're charged with, either ask myself or Mr. Haverco, who's here seated at the council table. Is Danny Alford here? Danny Alford. A number of people will not appear when after I processed everybody here. I'll go back to if there was probable cause for the issuance of the citation in the individual case that did not appear, a warrant will be issued for their arrest. You've saved yourself a warrant by simply showing up today. Danny Alford did not answer. Brody Bennett, there was a request for a reset on that from an attorney. I've signed that resetting the matter to May 11th. Sean Cook in the courtroom. Courtney Parkham. How about Zachary Hurst? Cirrus Houze. House. Sir, if you'd step forward and have a seat next to Mr. Haverco. Is your name Cirrus Tony?
No, it's Cyrus.
Cyrus.
Yeah.
And how do you pronounce your last name?
House, that's Houze.
Mr. Howes, you were cited with driving while license suspended or revoked in the 3rd degree. Now, this is going to apply to other people in the courtroom as well. Driving while license suspended or revoked in the 3rd degree is a misdemeanor. That means a conviction would subject you to up to 90 days in jail and up to a $1,000 fine. However, given the nature of the offense, the city customarily has a motion in that case. And the motion would be?
Yes, Your Honor, city moves to amend the charge to no vol in the 2nd degree.
Mr. House, what that did, it reduced the charge from a criminal offense bearing the possibility of jail time to a civil infraction, which can only bear a fine. That doesn't entitle you to a lawyer. If you admit the infraction, I'll assess a $150 fine. If you deny that you committed the infraction, we can set it for a contested hearing. Any question about anything I just said?
No, I don't think so.
Do you admit or deny that you didn't have a valid license on your person on April 13th?
I admit to, but I had not received any information of having a license.
Having it suspended?
Yeah.
What ordinarily, I don't know about your case, but what ordinarily happens is if you got an infraction, say you've got a speeding ticket and didn't show up on it, the court out of which the ticket was issued would send that infraction into the Department of Licensing as a non-appearance, a failure to appear.
Okay.
Department of Licensing would then send you a letter saying, hey, unless you take care of this within 30 days, I think your license will be suspended. And so what my guess would be is perhaps the Department of Licensing doesn't have a current address for you. That's ordinarily what I find. So what you need to do is check with the Department of Licensing. There's information, I think, on the council table there about that. We live in a world where you pretty much have to be able to drive just to function. So if there is an issue with your license, my suggestion is you get that taken care of as quickly as you can. The penalty is $150. You can pay that at the rate of $25 a day. And your first payment would be due May 27th the next month. Any questions at all?
No.
Mr. House, I'm going to wish you the best of luck. I'm signing today's order, and I'll say this for the benefit of everybody else in the courtroom. Electronically, this order entered today goes to the clerk's office. I want everybody to go to the window outside the courtroom and to your left and get a copy of the order for your reference. Mr. House, good luck to you. Thank you for appearing, and you have a great day.
Thank you.
Jeffrey Jones. Jeffrey Jones in the courtroom. How about Eric Lavarge? Christopher McGuire. Mr. McGuire, if you would have a seat. And good afternoon.
Good afternoon.
Full name Christopher James McGuire.
Yes,
Citation alleges that on or about April 15th of 2023, you committed the offense of violating the terms and conditions of a protection order. Now that charge is a gross misdemeanor. The possibility of jail time upon conviction would be 364 days. And there would also be a $5,000 fine that could be imposed. I'll appoint Mr. Haverco to enter a plea on your behalf, Mr. McGuire.
I think Your Honor would stipulate to probable cause, ask the court to enter not guilty plea.
Mr. McGuire, a stipulation to probable cause just means that you agree that the officer had a sufficient reason to issue the citation. That's a long way from proving that you had committed an offense beyond a reasonable doubt. Mr. McGuire will set the pretrial hearing for May 25th at 10 in the morning. 1657.
But why don't you write it down for me?
can you repeat that one more time, the next court date?
Pardon?
Was there another court date?
Yes. The plea of not guilty has been entered on your behalf today. We're resetting the matter for a pretrial. Now, conditions of release are always these: law-abiding behavior, stay in touch with your attorney, and return to court as directed. Mr. Haverco's information by way of contact is on the today's order, and he'll definitely want from you your telephone
You need
number.
to sign on this. Gotcha. Is it 7657? 657. Okay, 7392784. Yeah. Okay. Got it. You're free to go pick up a copy of your paperwork on the left. All right. Thank you, Your Honor.
Thank you, sir. Morgan Mahoney in the courtroom. Ms. Mahoney, good afternoon. Your name is Morgan Cheyenne Mahoney. You were cited for failure to transfer title within 45 days of acquiring ownership of a motor vehicle. That is a misdemeanor. Conviction would bear the possibility of 90 days in jail and or a $1,000 fine. Now, given the nature of this offense, the city typically has a motion in your case as well.
Yes, Your Honor, city moves to amend to expired tabs.
Now, what happened there is just what happened in a few cases ago. You were charged with a criminal offense. The city has amended the charge to a civil infraction. The difference is this: civil infraction, no possibility of any jail time. That's if you admit that you didn't transfer title within 45 days, I'll assess a $150 fine payable at $25 a month. You can deny it and we can set it for a hearing. Any questions? Would you like to admit or deny?
Admit.
Okay. Do you know what you need to do to get title transferred?
I went to the DMV and I got the paperwork. I'm already in the process of getting the rest of the money.
The general advice applicable to all of us, you're buying a car, make sure you get the title, because after you parted your money and got the car, the seller couldn't care.
Yeah, I've always bought them from dealerships, so I've always paid in full and had everything before I left the lot, but this time I bought it for my grandma. So I kind of messed up on that.
Good luck. It's now a simple non-moving violation. I might note for your information that I think Washington is one of 6 states out of 50 that still has this as a criminal offense. It's not the end of the world, not the most serious offense, but Ms. Mahoney, thank you for appearing, and that takes care of the matter. Get a copy of today's order at the window. And if you have any questions, any issues making the fine payment, let us know. We can deal with that easily.
Okay, thank you.
Thank you, ma'am. Jose Maldonado Orozco. Good afternoon, Mr. Mold. Solemnly swear or affirm that you will accurately translate from Spanish to English, English to Spanish, all that is said here.
Yes, sir.
Good afternoon, sir. Is your name Jose Camino Maldonado Orozco?
Yes.
The citation alleges that on or about April 19th, 2023, you committed the offense of driving while under the influence of intoxicants.
Yes.
That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $1,000, excuse me, a $5,000 fine. I'm going to have Mr. Haverco enter a plea of not guilty on your behalf at this time. Mr. Haverco?
Thank you, Your Honor. Would stipulate to probable cause and ask the court to enter a not guilty plea.
Mr. Maldonado Orozco, the plea of not guilty has been entered on your behalf. We're going to set the matter for a pretrial. Oh, boy. And that will be on. Conditions of release are going to be, don't drive unless licensed and insured. Don't drink and drive at all. And appear for court as directed. Your next court date will be May 25.
What time?
May 25 at 10 o'clock. There was an infraction also issued, and that will be calendared along with the criminal offense.
You need to.
Any questions at all? That concludes the hearing. Take care. Thank you for appearing. Thank you for your patience.
So I'm not gonna be able to drive.
Pardon?
The question for Mr. Maldonado is, I'm not going to be able to drive then.
Drive only if you're licensed and insured. That's the requirement. And don't drink and drive at all. Hey, that answer your questions?
Yes.
Okay. Mr. Mold, if you'd be good enough to take Mr. Maldonado to the window to get a copy of today's order, make sure May 25th, 10 o'clock is the hearing. Thank you much. Shane Maloney in the courtroom. Shane Maloney.
I should have it, so.
790-2780.
Yep.
Okay. Great.
Thank you, Mr. Maloney. Is your full name Shane Ryan Maloney?
Yes.
Mr. Maloney, the citation alleges that on or about April 17, 2023, you committed the offense of driving while license suspended or revoked second degree. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll have Mr. Haverhill enter a plea on your behalf.
Thank you, Your Honor. Stipulate to probable cause, enter a not guilty plea.
Mr. Maloney, a plea of not guilty has been entered on your behalf. It looks like you're also set for an arraignment on May 11th for another violation. We'll calendar that along with the current case, the case you're in court on now. Now, condition of release is, I'm not going to set bail on you, but a condition of release is don't drive unless licensed and insured. No law-abiding behavior. Stay in touch with Mr. Haverhill and apply and reappear for court when direct. Mr. Maloney, any questions at all?
Yeah, how would you get a pass for work travel?
Well, you call a work permit, that's in employment. That's something you need to talk to Mr. Haverhill. The last I heard that it was a work permit was not available pre-trial.
Yeah, I didn't think so.
That would be, and then I have no idea what the nature of the suspension, the alleged suspension is. Not knowing that. But Mr. Maloney, that's something you need to talk to Mr. Haverhill about.
I need your phone number.
253-231-0842.
Okay. Great. Thank you.
Pre-trial, May 25th, 10 o'clock in the morning.
Wait a second. I think we need to have the signs up there. One sign right there.
Mr. Maloney, thank you very much. You take care. Don't forget to get a copy of the order.
Thank you. Good.
Yep.
Brennan McCormick. Good afternoon, sir. Full name Brennan Amulek McCormick. I'm probably mispronouncing your name. For that, I apologize.
No worries.
City probably has a motion in your case as well. The citation is for DWS third.
Yes, Your Honor, city moves to amend to no ball in the second degree.
You probably know by now what that means. It's now a civil infraction. If you admit the infraction, the assessment is $150, $25 a month. If you deny it, we can have it set for a contested hearing. Any questions?
No, sir.
What would you like to do? Admit or deny?
Yes, I would like to admit. Could I also add,
Yes.
I don't know if this will change anything, but I did have a court appearance for my, the ticket that would cause my suspension yesterday. And so, the suspension should be, removed in the next couple days. It was-
Perfect.
Yes.
No, it doesn't. It's just very good news. It doesn't really change anything as far as what I'm going to do here, but as you know now, it's pretty easy to lose your license and a lot harder to get it back. A lot more of a nuisance. So that's don't get any infractions, but if unfortunately you do, make sure you get it taken care of. Mr. McCormick, thanks for appearing. It's $25 a month is the minimum payment. First payment due May 27th. And yeah, now that you have your license back, good idea to keep it.
Right.
Take care of yourself.
Thank you so much.
Thank you. Sean Moore in the courtroom. I don't get an answer. How about Tesla Moore? Elias Pettit does not answer. Kenneth Rager, Rager. I'm probably mispronouncing that as well. How about James Respo? Mr. Respo, good afternoon. Full name James, middle initial R, Respo.
It's Resop, sir.
If there's a way to mispronounce a name, I'm gonna do it and I apologize.
No, they have it spelt wrong, actually.
Ah. See if we can't get that corrected. Anyway, you were cited for two offenses: driving a license suspended, revoked third degree, and failure to transfer title. City may have a motion with regard to both of those charges.
Yes, Your Honor, city moves to amend the no on the second degree and expired tabs respectively.
That means it's now two infractions. If you admit the infractions, it's $150 each. If you deny them, we can set it for a contested hearing. First of all, any question about anything that's going on here?
No,
Do you wish to admit or deny?
I'm gonna take door number 2, and I'm gonna admit,
Pardon?
I'm gonna admit.
Wait, did anything you wanted to tell me? No, that was. No, that's okay. That's what it'll be. $150 each, $25 a month is on each of them. And of course, we live, like I said, we live in a world where you've got to be able to drive to function. So if there's an issue with your license, I'd make that I'd make it a priority to get it reinstated. Good luck to you, sir. And if you would get a copy of the citation at the window outside and to your left. Robert Rollins in the courtroom. Robert Rollins. Good afternoon, sir. Is your full name Robert Forrest Rollins?
Yes, sir.
The citation I have alleges that on or about April 23rd, 2023, he committed the offense of driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll ask Mr. Haverko to enter a plea on your behalf at this time.
I think Your Honor would stipulate to probable cause as the court can or not guilty plea.
Mr. Rollins, a plea of not guilty has been entered on your behalf. That preserves your rights pending a pretrial. Now, some conditions to release. There's usually a few more of them in this type of case. Law abiding behavior, no criminal law violations. Show up in court as directed. Don't drive a motor vehicle if you're under the influence or even in consumption of either alcohol or any prescribed drug. Any question at all?
No, sir.
City would request any additional conditions? That'll be the order then. Mr. Rollins, we're going to set the matter for a pretrial. That will be on May 25th at 11 o'clock.
It's gonna be 584 prefix.
584.
544 0734.
And we need to sign, right? Okay.
Mr. Ellis, that concludes the hearing. Again, get a copy of today's order at the window, and we'll see you back here next month. Good luck to you. William Schmidt.
Yep.
Schmidt, have a seat. You did have a hearing set for 2:30. Your attorney had an emergency that he had to deal with, so that matter is going to be Your name is William Paul Schmidt. Mr. Schmidt, go ahead and have a seat.
I prefer to stand if I can. Can I
Oh,
just-
certainly. Leave it up to you.
Okay, yeah, that's my name, William Paul Schmidt.
The citation alleges that on or about March 15th, 2023, you committed the offense of failing to comply with a lawful order of a police officer. I'll have Mr. Haverco enter a plea on your behalf. The plea will be not guilty.
I refuse anybody to offer a plea on my behalf. I mean, they can offer a plea on their own behalf of their behavior, but not mine.
Hey, your plea then is?
Pardon me?
Your plea is not guilty, I presume?
No, don't presume that. Why are you presuming that? I'm not in a position to plead. I haven't got discovery yet.
I'm going to enter a plea of not guilty on your behalf, and we'll
No.
set it for
That's, I don't know. if
Mr.
that-
Schmidt.
That can be legal.
Mr. Schmidt, if you can appeal any decision, anything I do.
So that would cost money, right?
Mr. Schmidt, I can't advise you. So you have a lawyer that's appeared
I'm
on
not
your.
asking for advice. I just asked a simple question.
We will set your case for a pretrial. Is Mr. Woody going to represent you on this? On the
Who's-
criminal
who's-
charge?
Who's standing up representing me? I
Right now,
am.
right now you are.
Okay, well, what a simple question. There's a simple answer. I am.
Okay, we're going to set the matter for a pretrial. And that'll be on, I presume, May.
Hopefully that'll be after I receive discovery. I mean, that's gonna precede any arraignment or anything else. I'm in no position to make a plea yet. I mean, I don't know what the discovery is gonna show. Do you know? I don't know either. So,
The
does that
pretrial will be-
does that complete our business here?
Not quite yet.
Okay,
The pretrial is May 25th, 9 a.m.
well, when will I just receive discovery? Hopefully, in time before that, otherwise, that'll be void.
What'll be void?
Pardon me?
What will be void?
The world.
Okay. Mr. Schmidt, the pretrial is set for a date certain. We'll see you back here then. Discovery is a matter. Have you filed your demand for discovery?
Pardon me?
Have you filed your demand for
Yeah,
discovery?
19th, 7 days ago, 8 days ago. There's been plenty of time. On my view, maybe it's,
Mr. Schmidt, that does conclude our business today.
Thank you.
If you would, could you get a copy of the today's order at the window outside the courtroom and to your left?
Okay, thank you.
Take care. Have a good day.
Yeah.
Robert Trevino. How about Scott Turner? Full name Scott Vincent Turner.
Junior.
Mr. Turner, the citation alleges that on or about April 20th, 2023, at the offense of driving under the influence of intoxicants. Again, that charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll ask Mr. Haverko to enter a plea on your behalf.
Thank you, Your Honor. Would stipulate your probable cause as to court to enter a not guilty plea.
Mr. Turner, a plea of not guilty has been entered on your behalf. Mr. Haverko will represent you throughout the course of your case. Conditions of release are do not drive unless licensed and insured, appear for court as directed, stay in touch with Mr. Haverko, and do not drive any motor vehicle having consumed either alcohol or a controlled substance. Any questions at all?
No, I think it's pretty straightforward.
May 25th, 10 o'clock would be their next appearance. And you can get a copy of today's order by going to the window outside the courtroom and to your left.
Okay, thank you.
For you,
Yeah.
need your phone number.
253-495-9114.
Yeah, before you go. Yeah. Let's go. Yeah, so on your way out, just turn right, and we'll give you a copy of the paper, which will have your birthday. I'll give you a call.
Jenny Underwood does not answer. Jenna White. John Wolf. Good afternoon, sir. Are you John Wolf?
Yes, sir.
Mr. Wolf, the citation alleges in honor about April 17th, you committed the offense of driving while license suspended or revoked third degree. City may have a motion in your case.
Yes, Your Honor, city moves to amend to no more on the second degree.
Mr. Wolf, by now you probably know what that means. It's been amended from a criminal offense to a civil infraction. If you admit the infraction, I'll assess a $150 fine. You have a right to deny that you committed the infraction, in which case we can set it for a contested hearing. Any questions at all?
Oh, that's fine. I did it.
Assess 150. Do you know what you need to do to reinstate your license?
Yeah, it's a whole big thing because I have other violations too, so.
Money.
Money.
It's money and it takes time to generate money.
Without a license and, you know, I just.
And without a license, it's hard to get to, it's quite an 8 ball to be behind.
Been a while since I've had one too, so.
Well, the best I can do is 25 a month. So, and again, copy of today's order, you can get at the window outside
Thank
to
you.
the left.
Must
be Mr. Wolf? Pardon?
I've been to court a lot of times and you are by far the coolest judge I've ever seen.
Well, hey, I thank you for saying that. I will try to live up to that. Thank you, ma'am. Caitlin Woodward in the courtroom. I've run out of names here at the end of the valley. Van, and sir, yes. And your name is? Last name?
Oh, was that?
That's, Mr. King, you're a little a little late. You're on the pretrial calendar. Thomas Nicholas Kinney. Mr. Kinney, prefer to
Well, yeah, I
reset?
mean, I would just ask, technically, he failed to appear at the required time, so just still note the FTA for speedy trial purposes and reset. Mr. Kinney, do you want to vote for a second? Well,
Is it notice of hearing in here? Do you want it?
so yeah, phone number?
Yeah.
Okay.
E78,
878
39,
3927. Okay.
Madam Clerk was good enough to prepare a notice of hearing.
Okay.
How far would you like to go?
You have your license back there?
No, I'm looking at it right now. I am. It'd be nice to use in this time, if I didn't have it, but, okay. I have.
No preference.
Of course, it's a little on the sluggish side today. Mr. Kinney, resetting your matter to May 25th at 10 o'clock. It's 10 o'clock. And you've been waiting patiently for court. Pardon, spell it?
Oh. So is he?
Yes.
Yeah, you can go ahead and take up this one. So the next matter, I believe, she said her name was Courtney Corkum. Yeah, number 4 comes on for arraignment for a theft charge.
Your name Courtney
2007.
Ann Corkum.
Yes.
Citation alleges on or about November 29th, 2017, you committed the offense of theft 3rd degree. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days incarceration and or a $5,000 fine. I'll have Mr. Haverco enter a plea on your behalf and he'll represent you in this matter.
Thank you, Your Honor. Would, excuse me, stipulate to probable cause, ask the court to enter a not guilty plea.
Ms. Corkum, a plea of not guilty has been entered on your behalf. Set the matter for pretrial. That'll be on May 25th. The case has a little bit of age on it, but I'm glad I'm glad to see you here today. 11 o'clock, May 25th.
Do you have a current phone number? Did you get a hold of it?
Joe 6 551 2430.
2430.
I come all the way from Seattle. Is there any way that I can do like in the afternoon?
No,
In the afternoon for sure. No afternoon then.
no, it's gonna be at 10 or 11.
No, okay.
Yeah.
Alright.
Okay.
What do that say?
Oh, it'll be in your paperwork.
Oh, yeah.
Yeah, before you go, yeah, take a left, go to the first one,
Okay.
and she'll give you a copy.
Okay, cool. Thank
But
you.
it'll be there, you bet.
No, good to go.
Yeah.
All right, thank you, Your Honor.
Corkum, again, conditions to release, law abiding behavior, and show up for court.
Okay, yeah, for sure.
Thank you for appearing.
Thank you.
Good luck. Good afternoon, ma'am. You were here for 1 o'clock court? And your name is?
Hmm. Yeah, well, why don't you come on?
Your full name is Tesla K. Moore? Ms. Moore, city has a motion in your case. You were cited for failure to transfer title within 45 days of acquiring ownership. Ms. Moore, you probably didn't hear what went on earlier. You were charged with criminal offense. That's what this is. Conviction would bear up to 90 days in jail and up to $1,000 fine. The city's amended it to a civil infraction. That means if you admit that you had expired tabs on the date you cited, April 17th, the penalty would be $150 fine payable at $25 a month. You also have a right to deny that you committed any infraction, and we can set it for a contested hearing. Any question about anything I've just said?
No question.
Do you wish to admit or deny?
I admit that, yes, I did have expired tabs at the time.
Right? 150, 25 a month, first payment, May 27th. I would make that a priority to get the title transfer.
Yes, sir. Yes, sir. I just got a job, so that's gonna be happening ASAP.
Good luck with that. I signed an order to that effect. I want you to get a copy of that order by going to the window outside the courtroom and to your left.
Okay, thank you.
Ms. Moore, thank you. You take care. Is this Danny L. Alford?
Yeah.
I did hear that one. Mr. Alford, you're a little late, but hey, come on up and have a seat if you would. Full name Danny, middle initial L, Alford.
Yep.
Mr. Alford, the citation alleges that on or about April 23rd, 2023, you committed the offense of theft in the 3rd degree. That charge is what they call a gross misdemeanor. The maximum penalty on conviction for that crime would be 364 days in jail and or a $5,000 fine. You have a right to have a lawyer. I'm going to appoint Mr. Haverco to represent you in this matter. He's going to enter a plea on your behalf at this time.
Stipulate probable cause, Your Honor, and ask the court to enter a not guilty plea.
Mr. Alfred, a plea of not guilty has been entered. That preserves your rights. We're going to set the matter for a pretrial. That'll give you a chance to talk to Mr. Haverco about your case. Resolve it if you can. If it can't be resolved, you have a right to a public and speedy jury trial in this county. Any questions at all?
No.
Pretrial is May 25th. And conditions to release or law-abiding behavior. Stay in touch with Mr. Haverco and appear for court as directed. Any questions?
What was that last part again?
Appear for court as directed.
Where you go?
Good idea to be on time.
Just remain seated. Sign this pad with this. Electronic thing. You won't see it. Oh, okay. And the phone number.
Would that be all right?
Just to call it.
Okay, yeah.
Yep, yep. Phone number.
Oh, okay. It's 253 888 3948.
Okay. All right. We'll be talking. Yeah, you're free to go, just take a left and go to the clerk's window and get a copy of your paperwork, it'll have your birthday. Okay,
Thank you.
all right.
Mr. Albert, thank you for appearing. We'll see you May 25th.
Thank you.
Take care. And that we have run out of people, we'll go off record. On record for the 1 o'clock no shows. First one I have is docket number 3, Sean Cook. Amend DWS third to Noval 2 and FTA that to the Department of Licensing. Next one I have is Zach Hurst. Find probable cause for hit and run attended on April 11th and probable cause for a violation of protection order. Same date. Find probable cause for each 1,500 cash or bond each. Next would be Jeff Jones. So Jones failure to transfer title within 45 days. Amend that to expired tabs. FTA that to the Department of Licensing. Try to keep this in order. Next no show I have is Mr. Labarge. Find probable cause for theft third. 1,500 cash or bond. For the issue, the next one I have would be Sean Moore. Way to the he was cited for 2 different things. The valid certificate of title, amend that to expired tabs and FTA, and then dismiss the license plate. Charge. That was kind of an odd case. Next would be Mr. Rager. Mr. Rager on 21, unless I missed somebody. Did I miss Pettit? Oh. Elias David Pettit, yes, I'm sorry that I put somebody in the wrong file. I did find probable cause for DWS third and ignition interlock, 1,500 cash or bond. The blue lights prohibited, that's a rarely cited offense. You see them all the time. Simply FTA that one. And on the April 16th, I did find probable cause for both theft third and crime trust 1. That was, he was in custody. I arraigned it release. So PC previously found on that. And still found. Now we get to Mr. Rager. Amend DWS third to Noval 2 and FTA. Mr. Schmidt. Attempted to send amended notices on that, but I think just let's leave it the way it is. It's on the calendar for 11th. Just no action there. Trevino, the docket says reset if and so simply reset that with notice. No warrant. Probable cause found. Next would be Jenny Underwood. She was also a previously found probable cause upon release from jail. 1,500 cash or bond warrant issue. And that brings us to Jenna White with another assault for 1,500 cash or bond. And go ahead and calendar the SOC one along with it, just to keep track of it. And last is Caitlin Woodward. That's DOS third, amend to Noval 2 and sent to the Department of Licensing as a failure to appear. Oh, that one is, I tried to keep Good afternoon. We're back on record. There's been a certain amount of confusion with regard to the hearing set for Daniel Hom. Attorney is present by Zoom, I'm informed.
Yes, I'm sorry, Your Honor. I didn't realize the time.
Oh, you did, yeah, the prosecutor gotten a message of some kind that you wanted to reset the matter because you had to be in some other court unexpectedly, but hey, and apparently here we all are, no camera.
I do, Your Honor. 1 second.
You'd rather not have that on, that's fine with me. Is the client present, or you waive his presence, or?
I would be waiving his presence, Your Honor.
Hey, that's, I have the police who requested the contested hearing, any preliminary motions of any kind?
Your Honor, I would to suppress the reading of the speed measuring device. The officer does not mention the serial number of the device. If it was checked, how it was checked. It's foundational. I have no idea what sort of speed measuring device it was.
You're kind of, you're sort of fading in and out, since you're in motion, I think you're in and out of contact here.
Sorry, can the court hear me now?
I can hear you a little bit better. Could you pull off the road?
Yes. Sorry. 1 second, Your Honor. Okay. Hopefully that's better sound now.
That's okay. I didn't hear you. You started in and then it turned into garble, but go ahead. Start
Okay. I would make a motion to suppress the results of the speed measuring device. The officer does not state in his narrative what type of device this was, what the serial number was, if it was checked, when it was checked, etc. There's a issue as to foundation on the results of that, and I would ask that that result be suppressed for that reason.
That's enough. Motion granted. Motion granted. The officer does reference just a speed measuring device without anything further, and without anything further, you're kind of at a loss to check that. Motion granted.
Thank you. Understood. Thank you for the court's accommodation. Again, I apologize for my tardiness. It was not my intention.
Okay, take care. Have a good one.
Thank you, Your Honor.
That will go off record.